Good morning, everyone. Welcome to this webinar by the Stanford Internet Observatory, part of the Cyber Policy Center at the Freeman Spogli Institute of International Studies and Stanford Law School. My name is Alex Stamos, Director Emeritus of the SIO and current lecturer and adjunct at Stanford, here with my incredible colleagues from SIO to talk about our newly released report from this morning, the strengths and weaknesses of the online child safety ecosystem. Next slide, please. Today, we are going to be talking about our findings from about a year of work of interviewing 66 people from industry, law enforcement, and civil society who work on online child safety, particularly with a focus of the NCMEC CyberTipline, which is the central coordinating technology that links up major platforms, law enforcement, NGOs, and all of those who are working on trying to keep children safe online. Our overall finding is that this CyberTipline is incredibly valuable, but it is not living up to its potential, that there are many people from across the spectrum who have a lot of different opinions on how these things should be handled legally, who still believe that the CyberTipline could be better utilized to keep children safe. You'll be hearing a great deal about this from my colleagues. But before we start, I want to thank the 66 people who we interviewed. We will be keeping them, for the most part, anonymous, unless there are situations in which they specifically gave us tips, quotes that they wanted us to talk about on the record. But we especially want to thank NCMEC, the National Center for Missing and Exploited Children, and their team for giving us extraordinary transparency, for giving us interview after interview, and then allowing us to embed with them for 3 days in their headquarters in Alexandria, Virginia, and to sit next to one of their analysts as we walk through how the CyberTipline process works. We believe we are the first academic group to have access like this, and I hope that this demonstrates that this kind of access and this kind of collaboration can help everybody in the future. Michelle has posted the link to our report. And what you'll be hearing now is first from our graduate student researcher, Sarah Shaw, who will be giving a background on the NCMEC reporting system. Then our research scholars, Shelby Grossman and Rihanna Pfefferkorn, who are really the biggest authors of the report and who I have to really thank for the incredible work they put into this. They're going to summarize our findings and our recommendations. Then we're going to have Q&A. So if questions come up as we go through, please put it in the Q&A tab. We'll have plenty of time at the end to answer that. We have a good broad swath of people here. So if it's a technical issue, if it's a policy legal issue, if it's a normative issue, all these kinds of things we'd love to discuss. Okay, so we're going to start off with Sarah. Passing to you, Sarah, to talk about a background on NCMEC and ICACs.
Awesome. Thanks so much, Alex. So let's start with some background. As you can see on the slide, in 1984, Congress authorized what is now NCMEC, or the National Center for Missing and Exploited Children, to coordinate searches for missing children. Today, NCMEC focuses primarily on fighting child sexual exploitation and abuse, and the cornerstone of that work is their CyberTipline, again, the focus of this report. The CyberTipline is a vehicle for members of the public and online platforms to report online child sexual exploitation. So anyone can make a CyberTipline report, but the majority of reports come from platforms. CyberTipline staff at NCMEC will analyze their report and ideally determine the location of the victim and the potential offender, and then they'll send that report to the appropriate law enforcement agency based on that information. If they can't determine a location, those reports are generally made available to federal law enforcement. Next slide. Okay, as you can see from this graphic, online platforms and members of the public submit reports through the CyberTipline, and then NCMEC forwards those reports to law enforcement, primarily federal law enforcement, international law enforcement, if the reports resolve to a location abroad, and actually the overwhelming majority of reports are referred outside of the United States, and ICAC task forces, which I'll talk about next. Next slide. Oftentimes, NCMEC will send reports to ICAC, or Internet Crimes Against Children task forces. And these task forces are essentially mixed bodies of local, state, and federal law enforcement that are dedicated solely to investigating and prosecuting internet crimes against children. They also train local law enforcement on how to develop an effective response to these crimes. There are 61 ICAC task forces in the United States, so some states have one task force, some have multiple. When a task force gets a CyberTipline report, it reviews the report and then it has to prioritize it along with, the number of other reports it gets every day or every week. They can choose to further investigate their report, send the report to an affiliate for investigation, or decide the report should not be investigated. Next slide. Both NCMEC and the ICAC task forces are funded by Congress, and that funding is distributed to each entity by an office in the Department of Justice called the Office of Juvenile Justice and Delinquency Prevention, or OJJDP. Both receive roughly the same levels of funding, which has increased over time, though many think the funding increases are not sufficient to resource addressing these crimes. In 2023, NCMEC received $41.4 million for over a dozen NCMEC programs, including the CyberTipline, and the 61 ICAC task forces received $40.8 million total. NCMEC also received some private funding and donations. Next slide. So over time, NCMEC has released more information about the CyberTipline reports it receives. Overall, NCMEC received 36 million cyber tips in 2023. Many people told us, however, and this is an important point, that they find this number unhelpful for several reasons because it doesn't really paint a full picture of the problem. It is a shocking statistic, but for example, 36 million reports doesn't necessarily mean 36 million unique victims or even pieces of content. So there are other statistics that help us better understand the scope of this issue. The overwhelming majority of reports are CSAM, but there has been a consistent upward trend in online enticement of children, including sextortion. In 2023, 245 platforms submitted reports, but 5 platforms accounted for over 91% of reports. So that's several meta platforms, including Facebook, Instagram, and WhatsApp, as well as Google and Snapchat. Just a quick note, more reports doesn't necessarily mean there's more CSAM on these platforms. It may just mean that those platforms are investing more effort in searching for and reporting CSAM. So again, more reports doesn't equal more CSAM. 41% of those 245 platforms actually submitted less than 20 reports. Next slide. And I'm going to hand it off to Rihanna.
Thanks. Let's advance one slide, please. Thank you. So the Fourth Amendment to the U.S. Constitution supplies a number of constraints on the CyberTipline ecosystem. As our U.S. viewers may be aware, the Fourth Amendment prohibits unreasonable searches and seizures by the government. What's unreasonable? Generally, a warrantless search is considered to be unreasonable. Importantly, the Fourth Amendment only applies to the government. It does not apply to private actors. With that said, the government cannot circumvent the Fourth Amendment by making a private actor carry out a search that it could not legally do itself under the Fourth Amendment. Next slide, please. And there are 2 important doctrines under Fourth Amendment jurisprudence that come into play when we talk about the CyberTipline. The first is something called the government agent doctrine. This says that, well, as some background first, there's a federal law in the books that requires that if platforms become aware of CSAM on their platforms, they have to report it in using the CyberTipline. However, this government agent doctrine says that if a private actor conducts a search not on its own behest, but at the government's behest, that private actor becomes an agent of the government. And that means that what used to be a private search has to comply with the Fourth Amendment. So for example, if a particular law enforcement agent or a particular statute or regulation so strongly encourages a private actor to conduct a search that the search is no longer primarily the result of the private actor's own private initiative, it's a government agent. Or where, with the government's knowledge or acquiescence, the private actor searches primarily in order to assist the government in its goals rather to further its own purposes, it becomes an agent of the government. And so this is why the federal law that requires reporting of CSAM, apparent CSAM that the platform finds on its service, expressly contains a disclaimer saying that it does not require platforms to proactively search or monitor their platforms for CSAM. Slide. So another doctrine besides the government agent doctrine under the Fourth Amendment that's relevant here is called the private search doctrine. And this says that the government may repeat the scope of a private actor's independent initial search without getting a warrant. But if it wants to exceed and go beyond the bounds of the search that a private actor had done, it does have to get a warrant for that. Remember, I said the Fourth Amendment doesn't apply to private actors. You or I could, in our private roles, search or seize somebody else's stuff, and the Fourth Amendment doesn't come into it. It might still violate some other law, but the Fourth Amendment has nothing to say about it because you and I are not government agents. The usual remedy for a violation of the Fourth Amendment is the exclusion of all evidence that results from a search that was unconstitutional. And that means not just the evidence that's found directly as a result of that initial unlawful search, but also if that evidence leads to further searches that turn up more evidence, all of that has to get suppressed too, because it's all downstream of that initial unlawful search. Slide. And taken together, if we consider the overall effect of these Fourth Amendment doctrines, it leads to the conclusion that the CyberTipline's viability completely hinges on the voluntariness of platform searches for CSAM on their platforms. While they cannot be required to look, many platforms nevertheless voluntarily choose to search for CSAM, and that's where we get the vast majority of the tens of millions of CyberTipline reports that come in every year. So far, courts have rejected CSAM defendants' argument that platforms are acting as government agents when they did those searches. And the courts will cite to platforms' own stated business interests in keeping this radioactive abhorrent material off of their services. If platforms were to be deemed government agents by a court, then the fruits of all those searches would be inadmissible against those defendants, and platforms would have to stop proactively searching for CSAM. So all of those voluntary searches that currently turn up those tens of millions of reports per year would have to come to a total stop. And that means that preserving the voluntariness of all of those voluntary searches that platforms are doing to look for CSAM is a common goal of everybody who's a part of the CyberTipline ecosystem. Slide. There have been a few court rulings that come into play here that have interpreted these two doctrines and that have greatly shaped the behavior of stakeholders in the ecosystem. Under the government agent doctrine, there's a district court case called Keith, and more recently, a 10th Circuit case called Ackerman, authored by then Judge Neil Gorsuch, that ruled that NCMEC counts as a government entity or agent for a variety of reasons. And that means that NCMEC has to abide by the Fourth Amendment, even though NCMEC doesn't even have warrant authority, for example. NCMEC doesn't agree to these rulings, needless to say, but it goes along with them rather than flouting them, because if it were to disobey those and act as though it were not a government agent, it would risk undermining cases that were affected by that decision. Next slide. So that's the government agent doctrine. Under the private search doctrine, both Ackerman as well as a 2021 Ninth Circuit case called Wilson held that law enforcement is not allowed, consistent with the Fourth Amendment, to open reported files without a warrant if the platform didn't view them first, because that goes beyond the scope of the private search, and therefore a warrant would be needed. This is a split of authority on this issue. So there have been other courts that have ruled that the government doesn't have to get a warrant if those unopened files are a hash match to known CSAM files. But nevertheless, what we heard from our respondents is that the safer course is to get a warrant in any case where the file hadn't been opened by somebody at the platform. And because of the Keith and Ackerman cases, NCMEC counts as the government for purposes of this private search doctrine ruling. Slide. And I'll turn it back over to Shelby.
Thanks. So now to turn to some of our findings. So among people who work in this space, it is very well known that law enforcement are simply overwhelmed by the volume of CyberTipline reports that they are receiving. Our contribution in this report is really to highlight a related and core issue, which is that law enforcement feel like they're unable to accurately prioritize reports that are most likely to lead to the rescue of a child. So many law enforcement officers who we spoke to have stories of a seemingly low priority report that blows up into a huge investigation. And so through our interviews, we tried to understand why that's the case, why it's so hard for law enforcement to accurately prioritize. And so to start off with our platform's findings. So first we find that when a platform decides to first start looking for CSAM on their platform, they're going to get a lot of hits, and there is going to be a huge backlog that they're going to have to work through. Platforms say that when they start reporting CSAM, it's actually quite confusing. It's not totally obvious to them sometimes how to get access to the CyberTipline API, and that even when you do have access to the API, integrating with it can be cumbersome. We find that many platforms are submitting incomplete reports. This is probably sometimes just due to a lack of engineering resources being committed to completing the reports accurately and consistently. But interestingly, we find that also it sometimes seems to be in part just a function of lack of knowledge of which fields are most important. So the CyberTipline forum has many, many fields. Most of them are not required. And for platforms that are new to this work, it's not always obvious which fields are the most important to complete. So to give a quick example for why this matters, many CyberTipline reports are of memes that technically meet the CSAM definition, are illegal, they have to be reported, but law enforcement are not going to prioritize these reports. So when a platform, and what you're seeing here is an excerpt from the platform CyberTipline reporting form, there's a little checkbox called potential meme, and when platforms check that box, there's basically no issue. NCMEC forwards these reports to a special queue, and law enforcement, for the most part, don't really prioritize these reports. However, when a platform submits a meme report and they don't check this box, it goes into a queue where law enforcement need to typically close out these reports. And while it only takes 2 or 3 minutes to close out each meme report, if you're getting hundreds or thousands of meme reports each month, that adds up to a lot of time that could otherwise be spent investigating reports, again, that are more likely to lead to the rescue of a child. So we find that NCMEC has ongoing communication with many high volume reporters, but less so, somewhat understandably, with low volume reporters. But many platforms, both high and low volume reporters, really crave feedback about how to make their reports more likely to be investigated. Many platforms find the lack of investigative follow-up on reports that they deem high priority extremely distressing. So one respondent told us that we don't get the indication that even our highest priority reports are getting worked, even though we work night and weekends to get them out the door as quickly as possible. We also find that many platforms are not members of the Tech Coalition, an industry coalition that shares best practices about how to find and report CSAM. So the base membership fee for the Tech Coalition is only $10,000, which isn't that much money, but if you're only submitting, 5 reports a year, you might not think that it's worth joining, and then you miss out on this type of useful information.
We found from talking to platforms as well as to law enforcement and NCMEC that the law has shaped how platforms behave in this space pretty greatly. As I mentioned, platforms conduct a lot of private searches and they report the CSAM that they find. However, some of those reports are automated without having a human review step in between. We heard from platforms that it's important for them to consider the well-being of their moderators in deciding whether a human should review files before reporting them to the CyberTipline. And there's also the consideration of capacity constraints. You only have so many people working for you and they only have so many hours in the day. As we saw from the screenshot previously, there is a checkbox that platforms can check to indicate that somebody at the platform viewed that file before submitting it as a report. However, a significant percentage of the reports that are received every year don't have that box checked. And even where the box is checked, there can be some ambiguity about what exactly that means. Different companies have different legal interpretations of what that checkbox means, which can make it unclear to law enforcement what was supposed to be indicated by that. So whereas sometimes it will mean that checking the box shows that somebody at the platform viewed the entirety of that file, we heard from our respondents that sometimes companies will check that box if the current report, that file, is hash matched to a file that had been viewed by somebody at the platform at some point in the past, possibly years beforehand. And so it's not always clear to law enforcement, did somebody look at the entirety of this file at this exact time? Relatedly, we talked about the government agent doctrine before. I mentioned that preserving the voluntary nature of all those searches is really important. And to that end, platforms have developed very coherent narratives about how they have business interests in searching for and eliminating CSAM on their platforms, which they are prepared to present in court if necessary. In addition, we heard from platforms that they try and keep their trust and safety teams who need to work with law enforcement to provide information, to follow up on reports. They have to keep them from getting too close to their law enforcement partners because there's a risk if they were to start taking direction or suggestions from law enforcement rather than from the platform's own internal legal team, that there might be a government agency issue arising there. With that said, we also heard some frustration from some of our government respondents with platforms in that sometimes platforms can be perceived as hiding behind the Fourth Amendment as a means of evading accountability for improving how they submit reports, what sort of information they report, all things that they choose to come up with and to report if they want to, but that the Fourth Amendment prevents the government side from putting too much pressure on them to do something in particular. Next slide.
So now I'll talk briefly about some of our findings about NCMEC. So a common issue in this space is that law enforcement will sometimes receive hundreds of reports that are about the same offender. And sometimes these reports are actually spread out across multiple law enforcement agencies. But even when they're all sent to the same agency, that agency might not understand that they're all reports about the same offender. So the word that is used in this space to describe the linking of these reports is called deconfliction. And NCMEC has invested a huge amount of effort into deconfliction. And some of these issues are outside of their control, but there was a sense among respondents that there's room for improvement here. And just like more generally, a sense that technical updates to the CyberTipline infrastructure are sometimes slow. And then once they're finally implemented, they're actually underutilized by platforms. So why is this the case? So this is in part the case because NCMEC as a nonprofit just can't compete with industry on salary for engineers. Indeed, the modal respondent we interviewed who worked in trust and safety at a platform had previously worked at NCMEC. That was like a very common resume. Additionally, and we expand on this more in the report, that the inability of NCMEC to use cloud services makes it hard for them to take advantage of pre-built machine learning classifiers. And then on top of all of this, law enforcement agencies, both in the US and then also around the world, have different user like case management interfaces that they use. And so even when NCMEC does update certain information, it might not always be visible to law enforcement depending on what kind of interface they're using. So there's no easy solution to that, but just to highlight that that's one of the issues we heard about. And NCMEC is in the process of doing something that seems quite useful, which is tagging old files that they were able to view, such that if a report comes in that has a file that they can't open, if it's a hash match to a file that they were able to see, they can share information about that previous file with law enforcement, which could help them triage.
So Shelby mentioned that there are old reports that NCMEC was able to review. Newer reports after those court decisions that I mentioned are reports that NCMEC will no longer open files that are attached to those reports if those reports resolve to the US, where those are reports of files that had not been opened by the platform first, as indicated by the file viewed by company checkbox. So this is important in a world where there's this hugely high volume of reports coming in, because before the very significant percentage of reports that, as I mentioned, don't have that box checked, NCMEC is no longer able to open up those unopened files in order to triage reports, to label them potentially as being viral content or meme content. They are in a position where they just have to forward that on to law enforcement, who in turn generally will have to get a warrant, as I'll discuss later on. And this means that, especially where the content is something that NCMEC hasn't seen before, which is the case because in addition to the recirculation of existing files, there's continually new child sex abuse content being generated and transmitted. NCMEC therefore experiences delays in being able to start trying to undertake victim identification and safeguarding efforts. So next slide. As I mentioned, under the government agent doctrine, neither the government nor, for these purposes, due to legal rulings, NCMEC can tell platforms or even pressure them to search for CSAM in the first place, tell them what information to look for, or what specific information to include in their reports. That said, platforms, by and large, that we talk to, they want to submit actionable reports. They want to have the reports be high quality, but the interactions between platforms on the one hand and government and NCMEC on the other hand are extremely cautious because everybody involved is very leery of tripping over the constitutional issues pertaining to government agency doctrine. We heard that it is not necessarily super obvious to platforms which of the fields in the CyberTipline reporting form are the most important for them to complete. The CyberTipline form has a lot of fields in it. NCMEC continually adds more fields, but it never deletes a field. And so this can be, we heard from respondents, kind of confusing, especially if you're rather new to the system or if you don't submit a whole lot in any given year. NCMEC does offer onboarding calls to platforms when they are new to the CyberTipline and just getting started, but neither NCMEC nor law enforcement has put the advice for platforms for best practices in reporting into a written document about how they could better submit better quality reports for fear of government agency issues coming up there. Instead, platforms have to go to the Tech Coalition, which is an industry group that only comprises platforms, doesn't have NCMEC, doesn't have law enforcement as members, in order to get peer guidance on how to follow best practices in submitting reports. But as Shelby mentioned, there aren't necessarily 100% membership among all the platforms that submit reports, in part because the lowest tier costs $10,000 a year. Next slide.
So now to move to our findings about law enforcement. So we find, consistent with previous work, that law enforcement officers are overwhelmed by the volume of CyberTipline reports that they're receiving. But again, as I mentioned, our core contribution here is really to highlight that they're quite distressed by their inability to triage these reports. So one law enforcement officer told us that he will have a stack of reports on his desk, and he knows somewhere in that stack is a child who needs to be rescued, and he just has to be okay leaving the office at the end of the day knowing that he wasn't able to get to that report. Interestingly, law enforcement are quite frustrated that platforms won't share their hunches with them. This came up a bunch of times. So platforms are often reluctant to put information into the CyberTipline report unless they have very high confidence in that information, because they're afraid that if they put something in the report that is incorrect, that it could mess up a legal case down the road. But law enforcement officers who are just so overwhelmed by the volume of reports really crave those hunches, and platforms are, of course, best equipped to understand the activity that's happening on their platforms. So to give a concrete example of this, a platform might have a suspicion that an account was hacked, and after it was hacked, it shared CSAM, but they're not 100% positive. But if law enforcement knew that, they might deprioritize those reports because perhaps the person who did the hacking is like at least not in their jurisdiction, maybe not even in the US. So there's a real craving among law enforcement for platforms to share these hunches, even at the risk of them getting it wrong every once in a while. As mentioned before, law enforcement get annoyed at platforms for failing to provide important information in their reports. There's also a sense from officers at local police departments who specialize in crimes against children that their higher-ups don't sufficiently prioritize the investigation of these crimes. So best practice appears to be that if an officer views an image or a video, that they write up a very detailed description of what they saw to be able to communicate the gravity of the potential crime with other people. But what they'll tell us is that they sometimes get the sense that their higher-ups don't even want to read their descriptions to avoid thinking about this issue, or they'll wince when they read the descriptions. This came up in other contexts as well, with judges not wanting to see this content and jurors potential jurors intentionally disqualifying themselves because they don't want to have to view a CSAM. And while this report really focused on US law enforcement, we did do a number of interviews with law enforcement officers abroad, and they have their own set of additional challenges, the largest being that it is extremely difficult for them to get additional information from the platforms beyond what's included in the CyberTipline report.
So for law enforcement in the United States, the legal rulings I've been talked about have had a big effect on how they go about their business. In light of the Wilson decision, especially with regard to the scope of private search doctrine, it's now general practice for officers to get a warrant before opening files that nobody at the platform had opened before submitting the report. There may be some leeway depending on the particular jurisdiction that a given law enforcement agency might be in to open those files without a warrant, because as I mentioned, there is a bit of a split of authority on this issue, but nevertheless, the safest course is to get a warrant. And as predicted in the Ackerman case, which is one of the cases that says private search doctrine means go get a warrant for unopened files, Ackerman had predicted that law enforcement would have no trouble getting a warrant in cases where there's a child sex crime involved. And indeed, we didn't hear of any instances where a judge had refused to grant an application for a search warrant that was based on a cyber tip. With that said, it takes time to fill out a warrant application, go before a judge, get the warrant issued, and law enforcement may put a lot of time into getting a warrant in order to open up those previously unopened files, only to find it's a meme, it's viral content, it's something that's years old. It's not something that will necessarily lead directly to the rescue of a child who's currently in danger. And because of the amount of time that can be invested in getting warrants, sometimes only to find that it's a meme, there can be a delay in starting investigations where there might be a child who is in fact actively at risk, whereas the ability to open unopened files might have cut shorter that amount of time that it would take to start up that investigation. One of the ways that we heard from law enforcement respondents that they have dealt with this warrant requirement in a world where they get a huge get hundreds potentially a day or thousands in a month, as Shelby was saying, the way they deal with this volume is to do what is called batch warrants. And this is where law enforcement will bundle together dozens or even hundreds of unrelated cyber tips into a single warrant application before submitting it to a judge. There's no necessary relationship among these. They don't pertain to the same offender, the same victim. They're just cyber tips that all get batched together. Not every judge will even grant these because there are some potential arguments about why they may be constitutionally infirm. But nevertheless, this is one way of dealing with the sheer volume in light of the warrant requirement. However, again, with the delays that can be occasioned by getting a warrant, doing follow-ups potentially with the platform in order to try and get IP address, link IP address to a subscriber, et cetera, because the federal reporting law only requires platforms to retain the data that they report to the CyberTipline for 90 days, by the time everything wends its way through the system, gets to law enforcement can finally follow up with the platform. Oftentimes, that data has been deleted by the platform because of often legal uncertainty or unwillingness to retain that retained data beyond the 90-day retention period, given how radioactive this is and given potential legal liabilities for letting this just linger around. And so that can mean that valuable investigative material is lost because of the amount of time that it can take from the time a cyber tip is first reported to when law enforcement finally gets back to the platform. I'll hand it over to Shelby to start our recommendations.
So first, our recommendations for platforms. So our main recommendation here is that platforms ensure they're investing sufficient engineering resources into completing CyberTipline form fields accurately and consistently. We also want to just re-emphasize the importance of the file viewed by company checkbox. Platforms should understand that if this box is checked, the report is more likely to be actioned, and it's just going to facilitate law enforcement triage. Platforms may still have good reason to not want content moderators viewing this content, but they should just be aware of that trade-off. And we also, again, want to highlight the importance of the potential meme checkbox. I think if platforms were more consistently checking this box, it would free up probably thousands of law enforcement man-hours to investigate more important CyberTipline reports. We've heard from respondents that the information that platforms can include in a report that will make the report more likely to be actioned are the who, what, where, when. So who being offender and or victim information, what being the actual file, where being ideally an upload IP address in addition to any address information, and when being the time of the incident, along with how the platform defines the time of the incident, including the time zone. We also encourage platforms to periodically audit their reports to ensure that there aren't any systematic errors in how they're being completed that could be easily addressed. In terms of NCMEC, we encourage NCMEC to prioritize investment in technical staff and the technical infrastructure of the CyberTipline. We encourage both NCMEC and the ICAC task forces to partner with researchers to kind of bring insights into the CyberTipline. I think like the most important type of research here would involve some sort of random sampling of CyberTipline reports and then a tracing of what happened to those reports. And that kind of research can only take place with cooperation from both NCMEC and either the ICAC task forces or federal law enforcement agencies. We encourage all local law enforcement agencies to affiliate with their ICAC task forces. This is not something that costs money, but this would allow ICAC task forces to send out more of their CyberTipline reports to local law enforcement and reduce the burden on them. And we encourage department chiefs to ensure that they are prioritizing the investigation of crimes against children. I think our main recommendation from this report is that we think there's a need for a concerted effort to uplift NCMEC's technical and analytical capabilities, and this can only happen if Congress gives NCMEC additional funding to hire engineers at more competitive salaries. And as with all of our funding recommendations, we do not think this funding should be taken out of the budget of the ICAC task forces, which are already themselves resource constrained. We also think to avoid state actor concerns, an organization that is not NCMEC should consider documenting and writing best practices for submitting high quality reports. And if there are reasons why such a document shouldn't be made public, for example, it might allow bad actors to game the system, perhaps this document could at minimum be shared with the 245 platforms that submitted CyberTipline reports last year.
On top of that, it seems like a fairly piece of low-hanging fruit to extend the current data preservation period from 90 days to at least 180 days, if not more, in order to more properly ensure that material is still preserved until the point where law enforcement can follow up. And then finally, I won't weigh in on which way this should go, but I would like to see the Supreme Court clarify how the private search doctrine applies to unopened files. We have that split of authority among the different circuit courts about whether it is okay to open without a warrant where there's a hash match to something that had been previously viewed by a human at the platform. It's also a little unclear outside of a scattered couple of unpublished district court decisions, whether viewing a partially viewed file and then reporting it the moment you see CSAM is sufficient, or whether you have to get a warrant to open the rest of a file that was not completely viewed by somebody at the platform in the case of a video. All of these are things where we heard a lot of hesitancy and concern and different legal interpretations by different platforms, in addition to law enforcement. And so the whole ecosystem, I think, would benefit from having a consistent nationwide standard to the extent that that is possible in what is often a very fact-intensive legal analysis. Next slide.
So before we open things up for question and answer, we just wanted to highlight an event that the Stanford Internet Observatory is hosting at the end of September, just because we thought it might be relevant for people who are joining us on this webinar. So we are hosting the 3rd annual Trust and Safety Research Conference. And if you are interested in presenting, you don't need to submit a paper. It's just like an abstract. And the deadline is the end of the month, April 30th. And while we encourage submissions on all types of trust and safety issues, we're always very interested in child safety issues. So I will now pass things over to Alex, who's going to facilitate the Q&A.
Great. Thank you, everybody. Like Shelby said, we're looking forward to your questions and to diving into this. So first one for Shelby. Shelby, why don't you talk a little bit about, the question was how many of the 66 interviewees were outside the US? Can you talk a little bit about our US focus here and some of the future research that we'd like to do?
Yeah, so I think maybe we interviewed 7, I'm going to estimate, law enforcement officers outside the US. There's a need for so much more research on the challenges that law enforcement faces in other countries, including in countries that have very strict privacy legislation, which can make it difficult for law enforcement there to map on IP addresses to individuals after very short periods of time. And there's also a need for more research on law enforcement in developing countries. So one kind of issue that came up in an African country, we heard that senior law enforcement officers are unwilling to make decisions or feel like they're not empowered to make decisions about what should and should not be triaged. And so as a result, law enforcement just feel like they're overwhelmed again, because they're also getting the meme reports and they feel like they don't have the authority to triage and potentially ignore the meme reports. So that's one issue that came up, and we're excited to do more research in the future on the CyberTipline in developing countries.
Great. Shelby, can you talk a little bit about more why the meme category is useful? Why is it so important that companies check that box? So
if companies check the meme box, even if no one at the company viewed the file, which is often the case, we suspect, for meme reports, NCMEC puts them into a queue that is called informational. And for various reasons, law enforcement then no longer needs to close out the report. So they no longer need to spend that 3 minutes closing out the report that really adds up. So as long as platforms are just consistently checking that meme box, even if people disagree about whether the meme meets the technical definition of CSAM, it won't cause any problems if they're accurately and consistently checking that meme box.
Great. We had a technical question I'll attempt to answer real fast, and then we'll see if David has more opinion. But there's a question of whether there's an attempt to address the risk of adversarial abuse of perceptual hashes. So the perceptual hash that's still the cornerstone of NCMEC's work in a lot of companies is photodNA. It has been extremely impactful, but it is quite an old technology. It predates the vast majority of modern computer vision research. And it is known that photodNA is abusable in a number of ways, that you can create pre-image collisions, as well as modify a human visible file in a way that still is human understandable, but also defeats the photodNA hash. And so there are a number of organizations working on alternatives. One of the lean alternatives is PDQ by Facebook in their white paper, which is on GitHub. This is an open source algorithm. They do talk about testing its adversarial, but then there have been people who have been able to generate collisions. So I do think this is a open area of academic research. And one of the things that we really suggest for NCMEC is to build an academic collaboration capability so that academic ML researchers, for example, can do work on their side by side with them on their data to do this kind of work in an open way to hopefully replace. I think one of the problems we have right now is there's a bunch of different new photo DNAs that are floating around there, and we don't have a lot of good standardization right now. David, anything I got wrong or you want to add to that?
No, I think that covers it.
Great, thank you.
I will actually, I will add there are some cases where like adversarial abuse is potentially more plausible, which are some of the self-submission hash sets. And those basically just have to be verified by platforms when there actually is a match on one of those. But that's kind of a balance between potential abuse and making it so that people don't feel like they're distributing material to another platform. It just happens in the browser.
Great. So we have a couple of questions asking about specific bills and whether we endorse them or not, or if they'd fix this problem. Instead of talking about specific bills, Rihanna, I thought I'd turn to you a little bit. Can you talk a little bit about the danger of touching the Fourth Amendment live wire here of, some of these bills create incentives for companies that might be dangerous. Can you talk a little bit about the risk of passing bills that punish companies that don't report CSAM?
Yeah, sure. So as I noted earlier on, the federal reporting law says that if you find out about a parent CSAM, you have to report it. And it disclaims any obligation to look for or monitor for CSAM. We've seen a number of bills that include controversial elements that would effectively punish platforms for not doing more to fight CSAM on their platforms. And I want to note, by the way, that this is not necessarily a Section 230 issue. Section 230 gets used as a punching bag for a lot of things, but Section 230 has never covered federal criminal law offenses, and it is part of the federal criminal code to have this reporting obligation for platforms. So the DOJ has always been able, and still is able, even without anything coming into it, without Section 230, to take action where platforms are disobeying their reporting requirements under the law. We've never seen, to my knowledge, any actual prosecution in court by the federal government of platforms for violating that obligation. With all of that said, to the extent that there have been bills that would potentially open up greater liability to platforms if they do not search, if they aren't searching harder, if they aren't looking for and reporting particular things, those all risk running afoul of the government agent doctrine that I mentioned, where if platforms are not searching out of their own recognizance, but rather because they have been pressured or even directly told by the government to do so, they could be converted into government agents, which would render all of those currently voluntary searches into mass warrantless surveillance. All of the fruits of all of those things that they would potentially turn up would have to get excluded from court. And so all of that legislation would backfire. It would not make the child safety detection system better. It would make it worse because it would risk requiring the shutdown of all of the voluntary search programs that currently happen. So while we see some bills that include elements that don't touch on that issue, like preserve things for longer than 90 days, well, Oren Kerr has written about the Fourth Amendment aspects of preservation requirements too. Nevertheless, there's a big difference, I think, between the sorts of bills that we see that try and punish and shame companies into doing more, which risks upending the whole apple cart here, and those that go for more technical amendments that don't risk pressuring platforms into doing something that they cannot constitutionally be forced to do.
Right. So to summarize, I think of all of the currently proposed things, the one that addresses some of our issues most directly is the Report Act, which does not have any Fourth Amendment, but hopefully does not have any Fourth Amendment implications. But a number of the other ones could upset this entire apple cart. Is that right?
I would say so. And we don't take a position on endorsing any given bill, but the Report Act has provisions in it that are consistent with the kinds of things that we've been talking about, including the ability to use the cloud to do technical processing and improvements, which is something that currently private cloud services can't touch anything to help NCMEC out because they would count as violating the law. NCMEC is the only entity, other than law enforcement, as said, that has any sort of immunity whatsoever for touching this sort of radioactive material. And so the Report Act includes elements that would allow outside vendors, subject to same limitations on immunity for intentional bad acts, et cetera, as NCMEC has, so long as they have cybersecurity requirements in place, outside platforms, cloud hosting services, outside vendors would be able to assist NCMEC, and that might be potentially a means of greatly improving the efficiency of the system over what it is currently. So that's one way where these liability concerns have potentially that have historically impeded the efficiency of the system could potentially be rectified through pending legislation.
Shelby, what percentage of those reports that NCMEC talks about are memes?
Yeah, so I think this is actually a very important question. The answer is we don't know, but the reason why we don't know is kind of interesting. So for 2022, NCMEC estimates that about half of the CyberTipline reports were not actionable. And they were either not actionable because the platforms did not submit sufficient information or because they were memes or viral. However, NCMEC doesn't break out those two categories. And I think there are very different policy implications if most of those are unactionable because platforms aren't providing enough information, or if most of those aren't actionable because they are memes. And so I recognize that it's tricky for NCMEC to provide these statistics, but maybe in the future, I think it would be useful if they could provide information about for CyberTipline reports where they can assess whether it's a meme or not, what percent of those were memes. I think that would be really useful information to share.
Great. Okay, here's an important question I think we all have opinions on. So I'll start with Rihanna, because she's done a lot of work on this, but then we can all answer. What is our feeling about end-to-end encryption and how that will impact NCMEC data and prosecutions going forward?
Well, so end-to-end encryption comes up a lot in these discussions, especially now that Meta has announced that starting in December, they've now started to make Messenger, the Messenger app, end-to-end encrypted by default. With that said, I've written extensively in the past about the many options that are nevertheless available to platforms based on metadata, which has its own privacy implications, or user reporting for dealing with child sex abuse material or other types of abusive material in encrypted contexts. It's important to highlight, if you look at the NCMEC report, the numbers, even WhatsApp, which has been end-to-end encrypted by default for years at this point, submits well over 1 million reports to the CyberTipline every single year. And that's for an entity that has no access to the contents of user messages unless those are reported by the user. They're able to do quite a lot with metadata and other signals that they collect. So I think that is my general message would be that this is kind of like AI, honestly, a technology that is there. It's not going to be put back into the box, and at least as to end-to-end encryption, perhaps unlike AI, has massive benefits for society and protecting the privacy of everybody, children included. And so that's something that everybody in this ecosystem, I think, has to work with rather than, in my opinion, keep pressuring back against.
David, Shelby, you want to add anything on encryption?
I mean, I would just say that, the problems that we've identified in the report are not a lack of volume of cyber tips at this point. So, when we've got this many reports and there's difficulty in actually processing them and getting them to prosecution, or so many of them are just not including the necessary data, not for technological reasons, but just because of implementation details. I think that is an area we should focus on right now. It does not require doing anything to end-to-end encryption.
Great. It's an interesting, very specific, nerdy, technical question. I'll answer real fast. Could NCMEC use GovCloud? So GovCloud is a AWS FedRAMP certified. So all of the major cloud service providers have FedRAMP high instances of their cloud services. Right now, our belief under the current law is that they could not use any. There's no writing in there for FedRAMP or anything like that as giving an excuse for cloud service providers to have access to CSAM. So some kind of change to the law has to happen. I think that would actually be a reasonable outcome here. If the law passes, would be for, instead of using the public AWS or the equivalent, would be for NCMEC to explore FedRAMP high. That being said, one of our goals of suggesting that NCMEC have the ability to use the cloud is to give them access to significant amounts of AI horsepower. And my understanding is that generally the FedRAMP versions of these cloud providers don't have as much AI technology, but that's something that we'd have to look into the details there. An important question there's a huge disparity between the number of reports and those passed to LE as actionable. Why is that? Shelby, can you just kind of give a quick overview of all? We have lots of findings on this, but why is it that so few of these reports that LE looks at are actionable? What are the major reasons here?
Yeah, so this just gets back to the who, what, where, when. And so if a report is missing one of those, it might be deemed unactionable. You know, it was interesting. We did an interview with a law enforcement officer who was at a police department that was very well resourced, and he had a whole team of people to help him with forensics and search warrants, search warrant applications. And, you know, he said, kind of at a theoretical level, like no report is ever truly unactionable. If you have like unlimited resources, yes, you can kind of get information to make it actionable, but just in practice, given the volume, reports are less likely to be actioned if they don't have you know, basic information about the offender and the victim, and then information about the incident. And then there are some instances of CyberTipline reports that don't actually have the file, so they have the hash, but not the actual file, and those are generally seem to be unactionable by law enforcement.
Great. Rihanna, there's an interesting couple of questions about how we talk about everybody's worried about liability. Can you talk a little bit about why platforms are afraid to either put their opinions in or to check the low quality checkbox? You know, how are liability concerns driving the behavior of some of the actors here?
It's a great question. And Shelby talked a little bit about how there may be differences of opinion about how much to put in about, we have a hunch about this potentially being hacked. What if what you tell law enforcement ends up being wrong? That might be a potential concern. I don't know that submitting a lack of information is motivated by a fear of liability. I think from what we heard from our respondents, a lot of the time it really is an honest just lack of knowledge about what the best practices really are there. Because the law is actually fairly ambiguous about what needs to be reported. As I've mentioned, Congress can't really tell them, like, report this, 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 and this. So that both leaves it kind of up to companies to decide, like, okay, well, here's what we gather, here's what we retain, here's what we can report, because everybody collects and logs different things. But also it means that it's kind of up to platforms to decide for themselves, like, what should we report, what do we want to report, what does this reporting law actually mean? And so that leads to, I think, quite a wide variety in the sorts of information and how actionable it may be considered by law enforcement that actually makes it into different companies' reports. So we heard when we were talking to NCMEC that they had very good things to say about some companies that they said consistently submitted high quality reports that would provide a lot of extra information in their reports, and then, you know, some that may, for whatever reason, either for lack of knowledge or they're submitting a huge volume of automated reports, it may be extremely bare bones and not necessarily actionable.
Great. There's a question of, does any of the case completion data from law enforcement get built back up to NCMEC and then to the platforms? David, you're the one who built SIO's cyber tip reporting. We have over 5,000 cyber tips in the latest in 2023, which puts us above a number of platforms. I feel pretty good about our revenue to report ratio here. Can you just talk about you know, what feedback do we get from cyber tips, and what is flowing back from law enforcement in this area?
So, I mean, there's two places that can receive feedback from law enforcement. That's NCMEC directly, or it's the platform that actually submitted the reports. I do not believe we have ever received any feedback. From when we talked to platforms, it is very rare for them to actually get feedback. And NCMEC will get it more frequently because they are more closely engaged with law enforcement, but it's pretty rare. And we also heard from law enforcement officers that they know they should be submitting feedback. They know that it's important to the submitters to know that their work is getting looked at and is having like a positive effect in the world, and they still just don't have time to do it. So it is a real deficiency in that ecosystem where people are just often never sure what the outcomes of any of their submissions are. So as for the solutions there, I think that there could be policy changes that do actually require that be part of the feedback loop, or it could be prioritization of departments themselves. But it appears mostly that this is a resourcing issue in the in the parts of law enforcement that are allocated to process the cases.
Okay, so we have time for one last question. We're going to do a turbo round. Everybody's going to get 30 seconds for their answer on this, starting with Sarah. What is the worst case scenario if public and private sectors do not take action in response to this report? Sarah, what's your worst case scenario?
Putting me on the spot. I am very concerned about the effect of generative AI on this process. I am not an expert in this area, so I am not going to opine too much. I know everybody else on this webinar has a ton of thoughts on this, including you, Alex, but I'm deeply worried.
Great, David.
I would say, something I brought up a couple of times, which is just that as the value of hash-based detection starts getting kind of outpaced by detection methods that will be necessary for the increase in generated content, which are produced very rapidly, and most of the content will be novel rather than a historical hash. I think that the mechanisms for that are very behind in development for detecting those generated novel instances. And I mean, worst case scenario, what we've talked about is just right now we can't handle the volume in the whole ecosystem, and it can get significantly higher volume than it is.
Rihanna?
I'll echo what's been said so far. I think I wrote a whole paper for Lawfare about AI-generated CSAM a couple months ago, and I think that it's threatened to overwhelm the system with reports of automatically generated material, where the legal liability all falls on the side of incentivizing platforms to report everything and let law enforcement and NCMEC sort it out. And so there's little incentive for platforms to do anything but report anything, whether it may or may not be AI generated, and continue flooding the system.
Shelby?
Yeah, and I'll just underscore that the implication of what's been said, just to make it very concrete, is that a higher proportion of CyberTipline reports that could lead to the rescue of a child are not going to be investigated.
Yeah, and I totally agree. I think generative AI has the possibility of completely, as bad as things are right now, of completely destroying the online child safety ecosystem, that we are on the verge, and we have to act now if we're going to stop that from happening. I want to thank everybody for coming. I want to thank all the people. When we look at the list of attendees, a bunch of people we interviewed are here. If you talk to us, we know you're tired of talking about child safety issues. Really appreciate that. I want to thank again NCMEC for their incredible transparency, and for the fact that there's a bunch of smart people there that could be doing anything with their lives, and they spend their time trying to keep children safe, even though it's very personally difficult for them. And I want to thank my colleagues at SIO, Shelby, Rihanna, David, Sarah Shaw, Renee DeResta, John Perino, Elena Christ, and our faculty director, Jeff Hancock. I'm incredibly proud of this team. And this is a little bit of a dream of mine for us to be able to get this work out the door. And I hope that it has some positive impact. Thank you, everybody, for coming. And you can read the report, io.stanford.edu, find all of our other work. And if you happen to be from somebody who likes to support this kind of work, either because you're an eccentric billionaire or you represent a funding organization, please contact us. I'm stamos@stanford.edu, because we'd like to continue to do this work both in the US, but as Shelby said, study these kinds of issues around the world. And this would be a great time for us to get that stuff lined up so we can do that over the next couple of years. Thank you, everybody, for coming. Have a great rest of your week.